Mr. President, distinguished members of the Tribunal, it is a profound honor to appear before you today representing the Republic of Indonesia. My name is Budi Utami, and I serve as a counsel for the applicant. The case before this tribunal transcends a mere dispute over maritime boundaries or fishing quotas. At its core, it concerns the boundaries of state power and the preservation of human dignity at sea. Indonesia contends that the respondent recent enforcement actions, characterized by the destruction of vessels and the prolonged detention of vulnerable fishers, represent a departure from the rule of law and violation of the United Nations Convention on the Law at the Sea, or UNCLOS. Submission 1. The disproportionality of enforcement actions. Our first submissions, Your Excellencies, concerns the destruction of Indonesian traditional vessels, violation of Article 731, while Indonesia respects the sovereign rights of coastal states to manage their exclusive economic zone or EEZ. These rights are not absolute. Enforcement measures must be necessary and proportionate. The standard of reasonableness as established in the MV Saiga No. 2 case, the use of force must be avoided as far as possible. The burning of wooden artisanal vessels, the sole livelihood of impoverished families, constitutes an excessive use of force. It is a punitive measure, not a conservationist one. Abuse of rights, Article 300. By opting for the most destructive means of enforcement instead of less harmful alternatives, such as escorting vessels out of the zone, the respondent has exercised its rights in a manner that constitutes an abuse of right under Article 300 of the Convention. Submission 2. Breach of due process and human rights. Turning to our second submission, the treatment of Indonesian crews, particularly the detention of minors. Incidental jurisdiction over human rights. This tribunal has the authority under Article 293 to apply the rules of international law not incompatible with the Convention. This includes fundamental human rights norms. Due process of law, the respondent has failed to provide prompt notice to the flag state and has denied detainees immediate access to legal counsel and translators. Special protection of minors. The detention of Indonesian children in adult facilities is a clear breach of the Convention on the Rights of the Child and the principle of humanity. Members of the Tribunal, at the heart of this dispute are human lives, including children held in conditions that defy international standards. The respondent's failure to provide prompt notice and legal counsel is a breach of the Convention. The detention of minors in adult facilities is a breach of our shared conscience. We urge this tribunal to affirm that the rules of international law mentioned in UNCLOS include the protection of the vulnerable. Justice for these crews is now in your hands. Thank you. Thank you.